Hello, my name is Hugh Patterson, and I'm a scholar at the University of North Texas and the University of Oregon. Today's presentation is a comparison of Thai and United States copyright laws as they apply to scholarly video resources. It's one of the presentations presented at the 27th Southeast Asia Pacific Audiovisual Archive Association Conference. Thank you for joining me today, and I'm happy to take questions at the end or via email later, even after the conference is over. My main points today are what I hope that we take away from this discussion is that the recording of jurisdiction of copyright is important to our archival records, and as is the production roles of who produced the video resource and the employment relationship that those individuals have when they produce the video resource. These are often overlooked in scholarly resource production as part of the production of academic research. So, and that's my general context. So as a disclaimer, I want to say that this is not legal advice. I'm not a lawyer. I study legal frameworks, but lawyers often say, don't listen to anyone on the matter of copyright who is not a lawyer. Well, okay. That has some merit, but my understanding is that as archivists and as scholars and as archive managers and preservationists, we need to understand some of the intricacies of the legal frameworks that we deal with to help us better perform our duties and to be the good stewards that we need to be in the institutions that we serve. So why are we interested in copyright? Well, we have sometimes some internal motivations and sometimes some external motivations. Some of our internal motivations is that archive managers, we want to avoid legal obligations. Becoming ensnarled in a legal dispute can take up time and resources where we might better put those to use somewhere else. So it's a risk mitigation strategy. And sometimes we feel a moral obligation, maybe to the creators or to the participants in the production of the video. And so we want to steward that well through the use of copyright. Sometimes we want to know about copyright because we feel maybe there's an injustice going on and we want to make some changes or participate in the change process happening for our legal jurisdictions. And so we need to know something about copyright to affect change in our context. Sometimes we just rely on copyright as a basic policy for distribution and access control. So those are some internal motivations. For external motivations, sometimes we are just told to record the copyright and, that's the end of the discussion. And that's just because we work at an institution that has, this policy and we just follow it. Okay, that's fine. There's nothing wrong with that. And sometimes as managers, though, we have a fiduciary duty to the content creators. We want to steward their resources well, to the donor, to the archives, the donors to the archive. We want to, show good stewardship practices. And so we have these other kind of outside pressures motivating us to understand copyright a little better. So what is copyright? Well, from a US perspective, it's kind of like this. Things exist and creators should have the potential to make them and make money off of them more than anyone else. Then as a government, often the governments come in and they say, okay, we will give you these privileges and then help enforce them. And so they create a copyright framework. And my illustration of this is kind of here on the slide. Is that all works exist in the public domain in time past, maybe in the future. So the public domain is kind of this conceptual category that's like underneath everything. And then certain protections are applied to certain types of materials. And those protections are copyright. So, for example, and those can vary by jurisdiction. For example, in Thailand, copyright is a little bit shorter than in the United States in general. And this is one reason why recording the jurisdiction of copyright is important. There are certain categories of resources like government documents, which are completely outside of the scope of copyright and they don't apply. And both Thailand and the United States have this category, and apply it to government documents. And by way of historical context of Thai-US copyright, the discussion has often been largely contextualized in the discussion of Hollywood and large movie industry participants who have a lot of money invested in video resources. One example of this is some trade. The special recommendation submitted to the United States Trade Representative in 1998 suggested that $19 million worth of infringement for just video resources was in that year alone. And following trade recommendations had different kinds of numbers and mixed numbers and categories. So, but it's been a long discussion in the academic and policy literature that it's been felt there's been certain piracy or infringement situations. But I think one of the things that's really important for us as archivists to look at is that Thailand, its government, and has updated its copyright laws in the last couple of years, I suggest that it means that there's change happening there, and this change is probably a good thing as Thailand is looking to engage with new international partners, and one of those is international treaties that kind of dictates the terms of copyright law is the WIPO Copyright Treaty. And this went into effect last fall, which was 2022 in October in Thailand. And it meant that Thailand needed to change some of its laws to become compliant with the treaty. And that's what happened earlier in 2022, and then it went into effect in October. My context is scholarly resources, video produced as part of a research project, often ethno-linguistic, ethnographic, oriented cultural heritage documentation via video, video used in language documentation. And in these kinds of resources, some of the very interesting questions that we have to deal with are the works created as part of a work for hire scheme? That is, oftentimes this type of arrangement will change who the copyright holder is. And do the works meet the threshold of creativity for copyright applicability? So if a work, we might assume, as the law in both the United States and Thailand suggests, that it applies on creation or first publication immediately. But if the resource is not a creative work that is covered under that type of legal scheme, then it's not the copyright can't apply to it. So and the third very interesting question is that because copyright expires at the end of its term, is it really the vehicle that is most appropriate for those who are seeking agency over the materials? Oftentimes the materials that we produce are certain ethno-linguistic minorities want some sort of to become part of the process of dissemination and have some sort of control over that, and be in that conversation. And so oftentimes simply looking at copyright is not the solution that covers all the interests involved. So let's just kind of look at what the law provides here in Thailand versus the United States, and just those two comparisons. Now, the Thailand legal system is a civil law system, whereas the United States system is a common law system. So the civil law system often looks at the law first, and whereas the common law system will say, okay, the law, how has the law been interpreted by previous court cases, and how do those court cases apply to this situation? So the evolution of law and the way that it's approached is different in the two different frameworks of the two different countries. Another big difference between the two countries is the term length, which in Thailand's life is 50 years for most entities, or if it's a organization, then it would be 50 years after the first publication, where term length in the United States is a couple years longer, 25 to 45 years longer. In both countries, it's assumed that copyright automatically applies. Now, within the Thai framework of copyright, there are moral rights and neighboring rights. Now, moral rights is the right of the author to be acknowledged in their work, and neighboring rights would be sometimes called performer rights, are the ability of those performers performing perhaps a musical piece or in a play or a performance of some kind, that they are acknowledged and that the use of the materials do not damage their reputation. So those things are not protected in the US framework. So understanding where the copyright is registered and if those moral rights have been exerted or performers have been documented is important as we produce materials. So some of the terminology is different between Thai and the US. So I'm just going to quickly go over this and summarize it in a third slide here. In the English translation of the Thai text and legal text, they use the terms reproduction and adaptation, communication to the public, and the letting for hire. Now, these are the things that copyright protects, right? So it allows us to give the benefits to accruing the copyright to other persons and license the rights. So these are the nitty-gritty of the copyright. In the US, we legal documents, we use different terms. So we have reproduce, derivative work, distribute, perform, and display, and authorize others to execute these rights. So let's just summarize that here. Reproduction or adaptation is very similar terminology to reproduce and derivatives. Communication to the public is essentially what is meant to or equivalent in distribute, perform, and display. Letting for hire and giving benefits and licensing rights is very similar to the US concept, or as described in rights to authorize others to exercise these exclusive rights. All right. Now, in the scholarly context, oftentimes the producers of resources want to share this broadly without requiring people to pay for the resource. And sometimes, so they want to freely distribute those rights. But the challenge then is that copyrights apply automatically. So they have to, in a way, be repealed on a per item basis. So how can we do that? Well, the Creative Commons licenses give us that vehicle, that legal tool to be able to say, well, the distribution of this resource is allowed until the copyright term is out of date, right? But in order to know when it's out of date, we must also know the jurisdiction, and that's not what's not always recorded. So Creative Commons licenses allow for the citation of creators. They allow with options for no derivatives, options for no commercial activities, options that the resource and or derivatives must be shared under the same license. So if you get something and you would have to, and you remodify it, then you would have to share what you remodified under the same license. Now, if you want to get not have any of those and you just want to put your resource in the public domain, then there's the public domain dedication. So like I said, recording the jurisdiction of copyright is important to archival because we need to know when do Creative Commons licenses end. When do the resources enter public domain? Because those sorts of questions impact our ability to manage resources as archival stewards. So recording the jurisdiction of copyright is important and archival. And this is the essential conclusion then that I hope that we take away is that when we record video resources, we need the production roles, the relationship, employment relationship, and the jurisdiction of copyright. So thank you very much.